So, hello everybody, you're very welcome back to Law Hero. My name is Jen and I make videos about the law. And today, this is a requested video. Somebody suggested it on my Instagram and then I put up a poll to see if people actually wanted to see it, and they did. It's a very contentious issue, so I was kind of on the fence about doing it, and I said I would leave 2 weeks before I actually did it. So I'm filming it today, Sunday, 2 weeks after the actual event. And what I'm talking about is the tragedies that occurred at Ironman Cork. So just so you know, I'm doing this within the context of FE1 tort law, and the reason I'm doing that is because I think it's a really good example of tort in action, and I have a hunch that it might come up on the FE1 tort in October. I mean, for me, it's a no-brainer. The COVID stuff came up during COVID. This is a very topical tort law example that has been highly publicised in the media. So even if it doesn't come up, we'll say winter 2023 FE1, it might come up next year in 2024. I actually, and I'm sure a lot of you know this, I don't follow media a lot. Anything I hear from other people. And this story was told to me by friends, obviously, but because I do so many triathlons myself, people kind of assumed that I was at this event. Now, I have done it twice myself, so just in case any of you don't know, triathlon, swim, bike and run. An Ironman triathlon is a specific brand of triathlon. There's two types of Ironman. There's a 70.3 and there's a 140.6 miles. The 70.3 is a half Ironman, and then the full Ironman is 140.6 miles. They were going to have both races because Saturday was deemed to be, I think the weather was too bad on the Saturday, so they were having them both on the Sunday. That's fine. That's usually what happens. Usually the half Ironman will be on the Saturday and the full Iron will be on the Sunday, but because of the weather that weekend, the two races were put on to the Sunday. Now, the reason I had chosen not to do the 70.3 in Cork this year is because I did it last year and I really didn't enjoy it. I've also done the full Ironman in Cork in 2019 when the swim was cancelled, and I didn't enjoy that either. And there's different reasons why I didn't enjoy it, mainly because getting into Youghal is a pain. It's like literally a one-way system in there. Paying for accommodation that time of year down in Youghal is also a nightmare, and I just all in all didn't have a great race experience. I found the roads around Middleton not great, so I just decided to do different 70.3s this year. I did Amsterdam and Staffordshire. So yeah, that's my little story. When it came to this race though, I knew loads of people doing it, and I was actually tracking people on the Ironman app and all of that, so like I had no idea that there had been tragedies. We only found out afterwards. Now, as this is as far as I know, I haven't done massive research into like all of the details because I know it's been so well publicised. I'm not going to go and recap. It's not important. What is important about this video here is the overarching principles, and that's what I want to get into. The reason I'm making this video is obviously I have an interest in tort law and I do triathlon, so it makes sense for me to make this video. That's why I'm doing it. I don't have any personal opinion about Ironman. Obviously, I'm a consumer of Ironman. I do 70.3s every year. I've been doing them since 2017. So this is nothing about Ironman. This is nothing about Triathlon Ireland. This is nothing about Cork County Council. Nothing. I have no affiliations with anybody. This is just my pure opinion on the factual nature of it. And I suppose I'm coming at it from the point of view as a lawyer who is used to doing these types of events, and also because in the FE1 we talk about factual scenarios and how we would apply the law to those factual scenarios. That's just the major caveat coming into this video. So let's start with the basics. So I mean, at the end of the day, sport and recreation is dodgy business, and that is why these big events management companies, because that's what they are. At the end of the day, they're event management / logistics companies. They move from place to place, selling their event and that is their product. You buy into the event. And the process is you sign a waiver. Now, don't click out just because you think, okay, well, that's the case, done and dusted, you sign a waiver. It's not as simple as that. And that's why I didn't follow any of the media coverage, because a lot of the time it's just people's opinion, and a lot of the time opinion comes from emotion and it's not based on fact. So what I like to do is look at the facts and try and keep emotion out of it, because the law is supposed to be reason free of emotion, and that's what we're trying to do here. So the general process is you sign up for the 70.3, usually a year in advance. And the reason for that is because they sell out so quickly, and also they're on a tiered pricing structure, which means that the earlier you get in, the cheaper it is. And when I say cheap, this is not a cheap event. The starting price is around €350, and that's before you put any petrol in the car, before you get all your gear, and before you get accommodation. Triathlon is not a sport for people who don't have money. There is no way I would have been able to do triathlon in my early 20s because I did not have an income. If you don't have a steady income, you cannot do triathlon. So you assume, and this is based on fact, that because of the high barrier to entry, and this is also from my personal experience, that the people choosing to do this race not only have means, some sort of means, may not be true for everybody, but generally you would assume that. And the second thing you would assume is that if they're planning to do this race, they know what a 70.3 entails. It's not the full Ironman, so it's 1900 meter swim, 90k bike, and 21.1k run. They know that that's the ask on the day, and they know that if they don't fulfill that ask, they will not get a medal. And this is before we start thinking about personal safety. This is before we start thinking about all those other kind of fringe things you think about when it comes to actually doing physical activity. So that's the ask, that's the price. So that was probably booked a year in advance. At the point of booking, there will be a section where you tick to say that you are medically able to do that. Obviously, they don't want anyone doing races who are medically not sound to do the race. So there's actually a tick box there. The usual GDPR stuff. You're giving a lot of personal details, but the kicker is the waiver, and the waiver is signed up a year in advance. And if we take a look at the waiver from Ironman, so just so all of you know, Ironman is a multi-billion-dollar publicly listed company owned by the Wanda Group, and I hope I got that right. It doesn't matter. It's owned publicly, publicly listed company owned by Chinese owned, and it is a for-profit venture. It is extremely profitable. As I said, there is a high barrier to entry. It is for people who have money. It is not a cheap venture. So they are very, very profitable. The headquarters of Ironman is in Germany. They have a formidable team, and the reason for that is because it's a product that works. And just so you know, Ironman, the name Ironman, it wasn't meant to be sexist or anything like that. It's just that it's just the brand name that came around because in the 80s there was an event created and they called it the Ironman, and basically if you were able to swim, bike and run around Kona, Hawaii, you would be called the Ironman, and then that's how it grew legs. And the reason we look at the waiver, it is because it is a contractual document between the participant and the event organizer to manage risk on the part of the event organizer. I'm sure you all know what a waiver is. I'm sure you've signed it before, but it is not to be taken lightly. It is very skillfully and carefully drafted by the lawyers of this company to reduce the risk of compensation, of payouts that inevitably come when things happen. The thing is, if you're able to expertly draft around every foreseen circumstance, then you are very well protected from risk. And that is the whole point of a lawyer. You are looking for someone to reduce legal risk, and you do that through a waiver. So now that we know that there is a fully fledged waiver in place between Ironman and the participant, let's now look to waiver under Irish law. So consent or waiver is a defence under Irish law for a tortious action, for example, negligence. And in common law, we had a tort called the voluntary assumption of risk, and that has now been abolished by statute, or in Ireland our statute is the Civil Liability Act 1961. And if you remember from your tort law, you may have studied section 34(1)b, which is the defence of consent or waiver. When it comes to a defence is not outright. So we already have the waiver here as a defence, but we know that no defence is outright. No defence can be used in a blanket fashion. So then let's try and figure this out. Who is liable here in the case of somebody drowning at an Ironman event? Is the defence of waiver strong enough, or do we need some more than that? So let's go back to our fundamental principles in tort. Let us go through some of the principles of negligence. If you have ever studied negligence, you know the first thing you need to do is establish a duty of care. A duty of care is recognised in many situations, but usually where physical injury or damage to property has been caused by carelessness. Usually when you think of negligence, you think of slipping in a supermarket, road traffic accidents, work-related injuries and illnesses. The courts have not extended duties to situations in which parties could not reasonably be expected to take care to protect the interests of another. So it's the reasonableness here that we're looking, and this is called the floodgates argument, because we don't want people becoming helpless and suing all around them. Otherwise you'd have a massive compo culture. We have a massive compo culture in Ireland anyway, but there needs to be some sort of reasonableness. They've drawn the line at imposing liability in situations where it might defy common sense, be onerous, unreasonable, or where the risk might be more properly carried out by another. So if we have a duty of care, then we need to look at the standard of care required. So when we think of duty of care, we think what would be expected from a reasonable person in the circumstances. We look at it through an objective standard. The reasonable man is expected to know the basic laws of nature, facts, of common experience, the habits of young children, and the basic laws of physics. So what your man on the street would know, he is expected to appreciate his own ignorance and limitations. He is not necessarily expected to heed every warning. The objective approach is modified in relation to individual disabilities and circumstances. The courts will have regard to weaknesses and proclivities. Where a person suffers a sudden onset, such as a heart attack or an epileptic event, he may not be held liable for the consequences. If, however, he might reasonably have predicted this possibility, then he may be held negligent for not avoiding or mitigating the uncontrollable risk itself. So, the next area McMahon tells us to look at is risk versus utility. So, we need to look at the probability of the incident, the gravity of possible injury, the social utility of the conduct, and the cost of eliminating the risks are relevant. The greater the likelihood of harm, the more reasonable and thereby negligent it is for the defendant to engage in the risky conduct concerned. If the defendant's conduct, and we assume here the defendant is Ironman, has a high social value and utility, is a factor that makes liability less likely. In contrast, where the activity has no social utility and is done for little good reason, the person is more likely to be held liable for its adverse consequences if they are at all foreseeable. Liability for omissions is also important. A local authority is not liable for the consequences of failure to repair the roads. However, if it does repair the road and leaves it in a dangerous condition, it may be liable to persons who are thereby injured. And this kind of comes from the premise that you cannot make public authorities liable for every accident. Being a human means that you're going to be getting out in nature and things are going to happen that are maybe foreseen, unforeseen, acts of God, flooding, rainwater, thunderstorms, sometimes when trees, when their roots expand under tarmac, you'll get these bumps in the road that I myself have crashed because of them. And who is to blame? Nobody. You can't sue Mother Nature. And this is why the courts and the legislature are always trying to make that gap between who is liable. And it is only in this case, like for example, with the roads, that if the roads are repaired, but it is done badly, that is when you have a cause of action, but not before that. We agree here, and my opinion is that Ironman owes its participants a duty of care. I think that is okay. The standard of care Ironman owes its participants is the next thing I want to look at. So when we think of some special relationship a la Headley Byrne, when we think of the Anne's two-step approach, who is my neighbour, the public policy considerations, and remember that the standard of care is not just adjusted to take into account personal characteristics of the defendant. There are no degrees of negligence. So we're looking at the probability, the gravity of the threatened injury, social utility, or the burden of cost of eliminating the risk. I think based on everything we have said that there is a likelihood of harm, and that's probably why they put in the waiver. There is gravity of threatened injury. There is a risk. There is a lot of precautions put in. The greater the risk, the greater the precautions. I think there is social utility to what Ironman does. There's a demand for it. But the cost of eliminating the risk is probably too high, in my opinion. And it reminds me of the case of Muldoon versus Ireland, where it was held that prisoners cannot sue the state for injury in prison as the cost of eliminating the risk is too high. So yeah, I think there is a duty of care. I think the standard of care is reasonable. I think the proximity and foreseeability issues now is what I'm going to look at. This is the relationship between Ironman and the participant. I think it is a reasonably close relationship, but I don't think it is a special relationship. At the end of the day, I mean, Ironman is an event organizer. It doesn't give tips on triathlon. I mean, it does give like some videos and stuff, but it doesn't tell you how to do the triathlon. It doesn't act like a coach. And I mean, at the end of the day, if Ironman were to go bust, somebody else would just pop up. So I don't think it's like a coach. I don't think it's like somebody selling you a house. I don't think it's like a doctor. I don't think it's somebody who looks after you. I think it's somebody who sells you a service that you pay for. And I think they could easily be swapped out as a provider. So I don't think they are special. I think they have a massive organization and the product they offer is excellent. But in terms of, is it a special relationship between me and Ironman? No, I don't think so. I could swap it out for another provider. I think the one that's really going to grate on my mind is foreseeability. Was it foreseen that this type of thing would happen? In my experience, arguably, yes, there was foreseeability that this type of thing would happen. And you can argue that this is why they put in the waiver, because at the end of the day, they can put in all the controls. They can work with the local authority to create a safe environment or reduce the impact of a dangerous environment. But of course, it is fully foreseeable that if somebody gets into difficulty in choppy water, that they could drown. It is fully foreseeable. The two kind of markers that we look for in a tort, which is causation and remoteness. So causation is where you demonstrate on the balance of probabilities that the defendant caused the damage. If you look at some of the rules around causation, you have to demonstrate on the balance of probabilities, which is the civil standard, that the defendant caused the damage. And it has to be proven by the plaintiff. So the but-for test is the factual causation. And how we describe that is, but for the defendant's actions, the plaintiff would not have suffered the wrong. So we also look at the material contribution test, which shows that it's the defendant's causative factor if it materially contributes to the plaintiff's injury. So did the defendant's actions materially increase the risk that an injury would occur? Looking at the causation here, to me, causation would be very black and white. For example, if a gantry fell on a participant, if a man-made structure that Ironman placed somewhere, one of the tents fell down, something like this, like that's why you have a health and safety officer at these events. If one of those things caused injury, and cause being the operative word, I think their causation would be very easily proved. Here, the cause of the injury was the sea. If we say that it was the sea that drowned the person, the cause of injury is the sea. Arguably, the person wouldn't have been in the sea but for the Ironman event. That being said, the Ironman don't control that environment like an employer controls their warehouse. So I think we kind of fall down on the causation argument when you apply the law to the facts. And then the final area you're going to look at before we look at so even if all of this is proven, even if we prove duty of care, whatever the standard of care is, that there was a breach of that duty of care, causation and remoteness, even if we prove all of this, as I said, we have the defensive waiver that we also have to look at. So let's look at remoteness. So when we talk of remoteness, we look at the remoteness of damage. This determines whether the resulting injury will be compensated. The defendant will be liable for the damage that was intentional, as intention dispose of any question of remoteness. And the classical test is the wagon mound test, when oil leaked from a boat in Sydney Harbour and encountered cotton, which was in the harbour. The cotton caught fire and caused damage to the wharf. The defendants were not found liable for the damage. It was held to be too remote a consequence. It was not reasonably foreseeable. If it was foreseeable, the defendant is liable for the full extent of the loss, even if the loss is such greater than expected. And of course, an exception to the rule of remoteness is the eggshell skull rule, where the defendant can foresee some physical or psychological injury to the plaintiff, and then they are liable for the damage which results. For example, in Smith v. Leach, the plaintiff developed cancer from being burned by metal at a factory, but the initial burn was foreseeable, whereas cancer was not. We also need to apply the test of res ipsa loquitur, which means that an extraordinary case where the facts are overwhelmingly in favour of the plaintiff, that the court decides to reverse the burden, and the defendant must prove that they were not negligent. This applies in circumstances where the cause of injury was in control of the defendant and the incident would not have occurred had proper care been taken, and that is normally applied in medical cases, and I don't think that is going to be relevant here. Causation, I don't see it. We looked at the defences. I think that the waiver will be a full defence here, and therefore I do not think there will be any damages payable to the plaintiff in this case. That is my opinion based on the facts. I hope you enjoyed me going through it. Please let me know what you think. This is just my interpretation of the law based on the facts. If you think there are any facts that I'm missing, please let me know in the comments, or if you want to add in on the debate. Again, this is just me using this for academic purposes. It's not anything personal. I am deeply saddened by the fact that two athletes are now missing from our number. Again, last week in Finland, we also had another athlete die. At my race at Staffordshire the year before, somebody died. There's too many people dying in triathlon, and it's not really being dealt with, I think, by authorities who do have a say and who can reach the masses around their heart health, around the danger that comes with swimming in the sea, that kind of thing. I think there needs to be more awareness, especially in Ireland. I worked as a lifeguard myself, and I can tell you that our level of awareness compared to other countries of water safety isn't great. Even the best swimmers can get caught. Some people ask me, would I have got in the water on that morning? I am very conservative when it comes to bad waters. I think it's because I've seen a lot of bad things down through the years, and I probably would not have got in. I put my personal safety above any medal, and I don't care how I look, if I look weak or anything like that. Just because I know of too many fatalities, I know of too many bad things that have happened. I've come off my bike myself, I've had some near misses, so that's my own personal opinion on it. Anyway, I hope you get on well in the FE1, and I will see you in the next one.